afternoon. I'm Robert Kelly from Stewart Title, and welcome to this, the first webinar in a series of 4 webinars, instructions to registration, in which Ian Quayle will be leading you through a standard conveyancing transaction, giving you tips acting for the buyer and the seller, and no doubt will explain to us that it's not quite as easy as instructions to registration, but he will, as well as highlighting the problems, also highlight some solutions for you. This is obviously an interactive session. There are a lot of people here, so if you do have any questions, please add them to the questions box here. We will try and deal with as many as we can during the session, but as well as these webinars, as many of you will know, we also run property forums, separate ones for residential property and commercial property, which enable Ian to deal with some updates on law on a monthly basis, but then we throw the floor open to questions from you. So what we'll do in the next session, we will send you details of that later. Next session, we'll take up some of the questions which Ian hasn't had time to answer today and give some answers there. So there will be some useful tips for you there. By registering today, you will get a copy of the slides, the notes, and a link to a recording as soon as that's been tidied up. Please feel free to share these with your colleagues, use them as part of your training for your teams if you would like to. Very happy for you to do that. And obviously, do remember there are 3 more forums in the series. Register for all of them so you will get a link to them. And on that basis, because we have got a lot to get through, Ian, over to you.
Thanks very much, Robert, and massive thank you to Stewart Title for inviting me along today. Do talk to Robert and his colleagues about your requirements with regard to defective title insurance. And I was fortunate enough to listen to Robert at a conference last week, and he emphasised the importance of making sure that you are aware of your obligations with regard to compliance and defective title insurance. And I'm sure Robert won't mind my mentioning the fact that he and his colleagues are more than happy to provide that training, be it virtually or indeed face-to-face. And the last point before we dive in, there will be a feedback sheet for you to complete at the end of the presentation. If you could take a little bit of time to complete that, we'll mention it again when we finish, but that'd be really useful for both Stewart Title and for myself. As Robert mentioned, for questions, what we've got is a chat and question facility. I will dive into that before we finish today, but as Robert says, lots and lots of things to talk about. So we're talking about acting for the seller or indeed acting for the buyer in connection with the preparation of the contract bundle. Of course, it's the seller's task to prepare the contract bundle if we're going to be CQS compliant and protocol compliant. So the first thing is to have a look at the steps that should be taken by the seller's conveyancer in preparation for the creation of the contract bundle. So number 1, check the agent's particulars. Obvious point. But sometimes, because we're so busy, we've got so much work on, that the estate agent's particulars are not looked at, and they should be, because they may contain issues that I, as a seller, or you, as a buyer's conveyancer, might be really interested in. A recent extension, the fact that garden has been recently acquired, or part of the garden sold off, or an issue with regard to some extension work or alteration work that's been done to the property. Important that you see the estate agent's particulars. It's also important that the seller client sees them to make sure that the seller is comfortable with what the estate agent particulars contain. If a property's been on the market for a while, it might be that the seller client's forgotten how the property is described, etc. You should also contact the seller and advise them what documentation they require on a freehold or leasehold sale. I'm not going to deal with compliance client verification issues today. I'm looking at the nitty-gritty of the conveyancing process. So the seller needs to know what documentation you're going to need from them, and when that documentation comes in whatever form it comes in, you need to audit it. And if documents are missing, the client needs to be told what else you need, or you need to make sure that you can get that documentation so that the contract bundle can be as complete as possible. This last point again is something that's overlooked, and it surprises me. It is necessary for you to audit the title in other words, to have a look at the seller's title and to see if there are any issues that can be resolved, any issues that require disclosure, or any matters that could prevent or stall or act as a block to the transaction proceeding normally. So when we talk about the auditing the title, if the title is registered, then we need to inspect all the registers. Is the address shown in the property register the correct address that we've been provided? Have we got the names of the registered proprietors? Have names changed? Have we got evidence of change of name? Are there any issues there that the buyer is likely to pick up on? As far as the title is concerned, in the charges register, what charges have been listed? Again, check them. When you're onboarding the client, the seller should have advised you as to which lenders have charges on the property. Again, check that to make sure what the seller is saying is correct. If it isn't, then perhaps alarm bells might ring on the basis that is the person that's instructed us, in fact, the registered proprietor. As far as those charges are concerned, again, if the client displays some issues with regard to their solvency, we might get redemption figures straight away, where the client tells us it's going to be tight as to how much money is going to be available from the sale of the property to facilitate another one. Again, redemption statements early on might be a good idea. Are there any restrictions on the title? If there are restrictions, can those restrictions be complied with? If the restriction cannot be complied with, should we be thinking about disapplying the restriction as a very early stage, or applying to cancel the restriction? Far better to do that than from the buyer to spot it as an issue, either before exchange or worse, after exchange, and we become really time sensitive with regard to getting an application off to get the restriction removed or disapplied. The other point I mentioned is the issue of notices in the charges register. If there are notices in the charges register, which interest in land do they relate to? Are there interests in land that are pertinent to the seller? So there might be a second loan or something, or some form of finance agreement, or some other form of interest in the land that's noted on the title as against the seller, but wouldn't be relevant as against the buyer, in which case, are we going to be able to deal with them before we exchange contracts and complete, or are we going to give an undertaking to deal with their removal at completion? An audit of the title, I think, is very important for two reasons. One, we can spot potentially any problems before they arise and get them dealt with. Two, we can consider whether there are any issues that need disclosing to the buyer's conveyancer. For example, in our charges register, there may be reference to restrictive covenants contained in a conveyance, and it may be that neither the land registry nor our client has a copy of that conveyance, in which case better when we're dispatching the contract bundle to the buyer's solicitor or conveyancer to let them know that this document won't be available. Also, when we're drafting the contract, it may be necessary where there's some form of defect in title to describe it as an encumbrance on the title. And of course, there could be defects in title that are capable of remediation. All of these things would be undertaken when we're auditing the title. Again, with regard to auditing the title, if we've got an absolute title, then all is well. Be careful that you might have an absolute leasehold title that isn't a good and marketable title, because there could be a warning in the property register that when the absolute title was registered, the land registry did not see a consent that was required out of a superior title. If we're looking at a possessory title, is that going to be an issue for the buyer, where the possessory title is the title on which the property is actually built? That could be an issue. If, on the other hand, the possessory title is simply a part of the garden that has been acquired at some point in the past, well, is that really going to be a deal breaker as far as our buyer-borrower client is concerned, or a deal breaker as far as our lender is concerned, where we're acting for the lender? Qualified titles, why was it qualified? Again, is it possible to remediate the title? Unregistered land, just talking to the land registry this morning about this, delays in first registration are a major issue. There may be some news from Stewart Title about this as an issue and a potential solution at some point in the near future. Hopefully more on that as and when progress is made. But with regard to unregistered title, what about asking as a buyer, asking the seller to voluntarily register? If you're acting for the seller, what about voluntary registration to ease the burden on the buyer with regard to the conveyancing process? And with regard to defects in title, if there are defects in title, interesting point. Do I, as a seller, solicitor or conveyancer, have to convey to the buyer that I'm aware of a defect? Well, it depends. Technically, if the defect is a latent defect, in other words, not obvious on inspection or obvious on inspection of the title, the position is that there would be an obligation to disclose. If it was obvious on inspection or obvious on inspection of the title, there would not be an obligation to disclose. But hey, let's think about things from a practical perspective. Surely it's better to indicate to the other side a problem relating to the title and to agree some form of solution rather than wait and to see if the buyer spots the problem. Because sometimes you might think, well, if the buyer doesn't spot the problem, we sell the property and we go skipping off into the sunset. I have a more negative approach than that and say, well, all right, the buyer's solicitor fails to spot the problem. There is a risk that at some point in the future, someone else spots it and it comes back to cause us problems or issues. Again, far rather, let's get the issue in the open and get it resolved. On the issue of defective title insurance, a few points. Obviously, our sponsors today are Stewart Title. They have a variety of different products, some online via their solutions platform, and bespoke policies. Again, I'm fortunate enough to do some work at the moment with underwriters within the Stewart Title family, and I have to say they are really clever people, really useful people. And if you have a problem or an issue with regard to a title that's unusual, it might well be worth speaking to Robert or Stephen or Freddie and the team to see if they are aware of a problem. They well have encountered such a problem in the past. They may well have a solution to the problem and may well have either a standard policy or be able to create a bespoke policy for you. However, I would always say from a seller's perspective, disclosing the issue to a buyer is the important point, and then I would always maintain it is for the buyer to take out the policy, but a seller either to pay for the premium or for a deduction in purchase price to take into account the premium is the appropriate way. Perhaps before we finish today, we could ask Robert for his view on that, but that would be my stance. The buyer is better taking out the policy rather than the seller for some reasons which we'll hopefully explain before we finish. But again, with a title, if there are problems, what is it? Can I resolve it? If I can't resolve it, should I disclose it to the other side? Where there is a problem, two issues on disclosure. One, really you should be asking your seller client's authority to disclose it to the other side. And secondly, do think about if a defective title insurance policy is to be taken out at some point in time, is that disclosure going to create a problem for me? Again, Robert, I'm sure can assist before we finish today, but my understanding is that if we're dealing with a bona fide buyer of the property, we can disclose A, the existence of a defect in title, and B, the existence of a defective title insurance policy if one exists, and that isn't going to invalidate the policy. But again, perhaps we can ask Robert that before we finish. If we are going to take out a defective title insurance policy, what is the defect? Secondly, is a policy appropriate? And as I've mentioned already, should the seller take out the policy? I think no, the buyer should take out. And again, important to check as to what the insurance policy is indemnifying against and making sure that our client is aware of what is covered and indeed what's not covered. One of the things I always say to conveyancers is the profession is brilliant at telling clients what we're going to do, but we're not so good at telling clients what we're not going to do or the limitations with regard to our work. And I think the same thing applies with defective title insurance policies. We're great at telling the client, look, we have a solution to the problem, but are we telling the client there are other potential solutions that may be equally beneficial to the client? Is the client aware that the defect in title still exists and could be a problem at some point in the future? And finally, before we leave this slide, again, something very important from an insurer's perspective, does the client understand their duties and obligations that they owe to the insurer, not just during the conveyancing process, but thereafter during the life of the policy? So disclosures to third parties, a failure to provide an insurer with copy correspondence that was received relevant to the defect, relevant to the policy, all of which could create problems for the client. The client needs to understand that. I always maintain if we're taking out a policy of insurance, the client is made aware of the policy when the policy is taken out. But as an additional safety measure, I would notify the client at the end of the transaction and remind the client about the existence of the policy and the client's duties and obligations arising from it. Okay, so we've done our audits, we've done our preliminary work with regard to the transaction. The next thing that we've got to do is we've got to obviously prepare our contract and indeed the contract bundle. The first of those tasks is drafting of the contract, a relatively simple exercise, provided some sort of golden rules are adopted. The second thing that we're required to do is download official copies of the register. As far as that downloading exercise is concerned, remember that what we are doing is downloading official copies of the register, which is proof of our seller's title. In downloading official copies of the register, we are obliged to provide the buyer in the contract bundle with any documents that are referred to therein. Where documents are referred but are unavailable, then they should be listed as an encumbrance on the title, so the buyer knows as to the status of the documents and the fact that the conveyancing process is not going to reveal their existence or copies. The next thing that we need to do with regard to the register is, or the registers, is just as I said earlier, cross-check information in the registers against information that our seller client has produced. One, to make sure that the client and the documentation are consistent with one another, so that we're producing a contract bundle that isn't going to generate problems or questions from the buyer. And two, as a sort of an audit as to our client's truthfulness. So where our client tells us that property is burdened by a charge in favour of the Halifax Building Society, but the charges register reveals in fact that the charge is Santander, and that there's a further charge in favour of Mercedes Finance and another charge in favour of Barclays Bank, then alarm bells should be ringing and the client should be questioned or challenged why they've told us one thing and the documentation reveals another. The last point to note with regard to downloading official copies of the register is to check the seller's addresses for service as revealed by the registers. Where the client has told us of a correspondence address or a home address and the address for service is revealed by the official copies of the register is different, then the client should be challenged about that fact. Why do we have a discrepancy with regard to client's contact details and addresses for service? They may well be a logical and sensible answer. They may well be a potential warning or alarm bells ringing with regard to seller identity fraud. As far as the title plan is concerned, again, if I was going to do a belt and braces job with regard to a seller, I would send a copy of it to the client seller to ask the seller client to confirm that the plan accords with what their understanding of the extent of the property that they're selling is, just in case the buyer spots an issue or a problem or a discrepancy in that regard. We're going to have to ask our client to complete the TA forms, which we're going to delve into and have a bit of a deep dive into those issues before we finish, and any other documents that could be produced. Again, as far as that is concerned, there could be all manner of different documents that are being produced, correspondence with neighbours, correspondence or documentation received from planning or building control. Again, the client should be told that what we should be doing is generating a contract bundle that includes all of these documents. The client should be warned that where information or documentation is complete, that at worst, at best is likely to cause a delay, and at worst could mean that the transaction stumbles or even falls at the first or second hurdle as a consequence of a buyer being unaware of something until later within the transaction. As far as drafting the contract is concerned, again, a simple task, and therefore, as a consequence of that, the importance of proper completion of the contract often overlooked. Of course, we're not going to know the date of the contract until the date we exchange. We are going to know the seller's details from the title that we just examined earlier. The buyer's details we'll get from instructions from the estate agent. Some firms don't insert the buyer's details. I always do and always did. As far as the property is concerned, if it's freehold or leasehold, and the address of the property should be inserted. As far as title number or root of title is concerned, again, title number from official copies of the register, root of title, in essence, and put simply, conveyance or legal charge that's at least 15 years old. Specified encumbrances, we've got a general statement that we normally trot out when dealing with registered land. all matters contained or referred to in the various registers of the above named title. Remember that there may be particular issues or problems regarding the title that should be specified. Latent encumbrances, matters that are not obvious on inspection, not obvious on an examination of the title, should theoretically be disclosed in this part of the contract. As far as title guarantee is concerned, where a seller is selling a registered title, and that title is registered with an absolute title, then the general proposition is that a full title guarantee should be offered. A full title guarantee, put simply, is a statement that when the buyer acquired the property, appropriate due diligence was undertaken by a solicitor or conveyancer, and during that process, nothing was discovered by the seller on acquisition that should be shared with the buyer, and also during the seller's ownership, nothing has been drawn to the seller's attention that again would dissuade a buyer from buying the property. So a full title guarantee is in essence two promises, assurances or covenants from the seller. A limited title guarantee is in essence an assurance from the seller that during their ownership of the property, nothing has been drawn to their attention that would dissuade a buyer from proceeding to complete their purchase of the property. So you'll normally see a limited title guarantee being offered by an executor. You may come across a situation where no title guarantee is offered, so no assurances are being made as to the quality of title being offered. This might arise where you are buying from, for example, a trustee in bankruptcy or a mortgagee in possession. Completion date is left blank, obviously, until we exchange contracts. The contract rate will normally be a rate over and above the base rate of the seller's solicitor's bank. Again, with regard to contract rates, be careful. From time to time, you might come across an unusual contract, particularly from a small scale builder, where the contract rate is quite significantly higher than what would normally be expected. A buyer client should be made aware of that fact and it drawn to the buyer's attention, particularly where there's a sale or purchase, that we could be awarded contractual interest at a rate in connection with our sale, where we've got a defaulting buyer, but we could be liable to a significantly higher contract rate in connection with our dependent purchase. And we could be in default on our dependent purchase because of the default in connection with our buyer on our sale. So the discrepancy in contract rate could mean that we're paying out compensation on our aborted or delayed purchase, but not recovering contractual interest on our aborted or delayed sale. Purchase price as per agent's particulars. Deposit, we're not going to know until we exchange contracts. A seller should be aware of 2 points. Firstly, where the seller is willing to accept a reduced deposit, the likelihood is that if the buyer defaults, the buyer, although obliged contractually to pay the balance of the deposit, is unlikely to be willing to do so. So our client seller may have to bring proceedings to recover the balance of a deposit where, say, a 5% deposit has been agreed. Secondly, a seller needs to know that generally, where a buyer defaults, the seller will be entitled to retain the deposit, but there's no guarantee that that will be the case. Section 49 of the Law Property Act 1925 states, in those circumstances, that the court has discretion as to what is to happen to the deposit in the event of a defaulting buyer. Where the default is through no fault of the buyer, a court could order that the deposit is returned in full, or is more likely to order that a portion of the deposit is returned in full. Where a seller, where a buyer defaults, sells elsewhere, but gets a purchase price greater than the defaulting buyer was supposed to pay at completion, again, you may get a situation where the deposit that was paid by the buyer to the seller on exchange is returned in full. The thinking behind that is the seller hasn't sustained any loss. If he was selling to the abortive buyer at 450, but in a rising market, he's now selling to the new buyer at 510 or something of that nature. Again, as far as contents price is concerned, when we're drafting a contract where we're acting for a seller, we need to be careful. One, the seller will be completing the form TA10. The TA10 will list those items that should remain that are being taken and those items that are being left. Those items that aren't described as either fixtures or fittings, but need some form of description. And again, a decision taken as to whether they're being left or being taken. And it may be that there are some items that you would imagine that are being taken that are being left. The position needs clarifying in connection with the form TA10. The form TA10 will normally be annexed to the contract, and the contents price should be stipulated in the contract. The contents price will not attract SDLT, whereas the purchase price will, and the content price should be a true value of those items that are being purchased by the buyer in addition to the property itself. There is an opportunity here potentially for SDLT fraud. If I can inflate the value of the contents that I'm buying over and above what they are worth, and in doing so I'm reducing the purchase price for the land so that the SDLT level or trigger or ceiling is evaded, that would constitute fraud against HMRC. And in those circumstances, the buyer client could be liable in connection with that fraud, as it has submitted an SDLT return on information that is fraudulent. The buyer's solicitor or conveyancer, in submitting a return and knowing the return is fraudulent, would also commit an offence. A seller's solicitor that drafts the contract that includes an apportionment that is unreal and untrue, again, could be in the firing line, as could the seller for signing the contract and allowing the transaction to proceed, again, knowing that the price that is being paid by the buyer for contents is raised inappropriately, facilitating the buyer participating in fraud as against HMRC with regard to SDLT. Again, the client, where you're drafting a contract that is a bit weird and wonderful, say on the sale of part, I would probably send the draft contract to my seller client for approval before it goes off with the contract bundle to the buyer. But here we're looking at a straightforward contract in connection with the sale of a freehold or leasehold property, not a sale of part, and therefore there isn't too much to worry about. If we look at special conditions, the contract incorporates standard conditions of sale, 5th edition, the small print within the contract, remember. Where we are adding special conditions to the contract, a very important point, always check to make sure that the special conditions we're inserting are consistent with the standard conditions that already exist on the contract. Because where there is a discrepancy as between the two, then potentially those clauses are void, and depending on what those clauses relate to, the entire contract could be void as well. So be careful. The contract refers to the fact that the title guarantee is specified as per the front of the contract. It also lists those items which are included in the sale and those items that are excluded from the sale. Item 4, the property is sold with vacant possession, or the property is sold subject to tenancy. A number of points here that are worth exploring. Where you have someone in occupation of the property other than the sellers, or where the property is subject to a tenancy, it is important when acting for the seller to identify the status of the tenant or leaseholder and to have some form of communication with them direct to confirm the position. I'd be very reluctant to accept my client's word that someone had a license to occupy rather than a tenancy, or my client telling me that this is an assured tenancy as opposed to any other form of tenancy without seeing documentation and support. And where there isn't documentation, I'd want to clarify the position with the tenant or occupant directly. The reason for that is that the seller client may be mistaken. The seller client might be deliberately trying to hoodwink the buyer into thinking that the occupant doesn't have any form of legal rights when they do. And again, The problem with this is that it's all well and good completing the transaction on the basis that the occupant has a license which can be revoked. If when the buyer buys and he or she attempts to revoke the license and the occupant then shouts foul and says, I'm a tenant, then all right, we can sue the seller for breach of contract and not selling with vacant possession, but that implies that we're going to have to bring proceedings with all that goes with those proceedings, cost, risk, anxiety, etc. Better, from a seller's perspective, to get clarification as to the status of the occupant, and for you as the solicitor or conveyancer for the seller to have the comfort of either having documentation or direct contact with the occupant to clarify what your seller client is saying to you. Not for the life of me that sellers will, deliberately lie, but I am saying that sellers from time to time may make mistakes. I remember years ago acting for someone, and he had advised that the tenant had a short-hold tenancy. In fact, the tenant had a tenancy for life. Buyer buys, thinking that the tenancy can be brought to an end, only to discover that wasn't possible. In the end, litigation threatened, matter settled, but it was quite an uncomfortable position for the seller to be in. Now, I'm fairly confident that the seller was mistaken as to the information that was provided rather than a deliberate lie. But nonetheless, either way, it created a problem. Okay, latest time for completion. Is it going to be 2 p.m. or are we going to specify an earlier time? Clause 6, again, preventing misrepresentation claims on the basis that where a representation is made, liability can only arise insofar as it is in writing. Again, as far as liability is concerned, we can't exclude liability for fraud, or we can't exclude liability for representations that mean the buyer gets something radically different to that which the buyer thought he was getting. Occupier's consent, again, if I'm acting for a seller, I'm not going to be happy that my client is telling me that the great aunt lives in the property, but she has confirmed that she will move out when contracts are exchanged or when the sale takes place. We need to verify that information from the occupant, get confirmation in writing from her or him, and make sure that they sign the contract. Where there's any resistance or any sort of doubt as to the occupant's status, it may well be prudent very early on in the conveyancing process to ask the occupant to take independent legal advice before sort of signing the consent or making any form of admission to you with regard to status. So drafting the contract is a relatively simple exercise. However, I've touched on one thing that will complicate matters, namely sales of part. Great tip if you're drafting a contract for a sale of part. One, always make sure when you're drafting the contract you have a TP1, a transfer of part land registry form on your desk. That will immediately draw to your attention, one, do I need to think about the imposition of restrictive covenants on the land that I'm selling? Should I be thinking about imposing restrictive covenants on the land that I'm retaining? Are there easements, rights of way, rights to park, rights to store, rights of support, etc., rights to drain that I need to grant or reserve? Again, all important issues. Other points to note when drafting a contract: if we're drafting a contract in connection with an auction sale, there are conditions of sale that will appertain to a face-to-face auction. Where we're dealing with an online auction, again, it's important if we're acting for a seller to understand what the auction house requires of us with regard to a contract bundle, and also important that our client understands what the auction conditions of sale are and to what extent those auction conditions have implications for the seller. Just been doing some research on this recently, where an online auction house excludes liability for just about anything and everything as far as the auction house is concerned. And the interesting point with regard to that is that if you look at that, that means that the buyer is unlikely to have any form of right of redress as against the auction house, which in my view increases the potential for a claim being made against the seller. Next thing to talk about the TA forms. I'm going to talk about the TA form in standard form, the existing version, and the revised version for a minute or two. Number one, there is a warning on the form, as you can see, that the seller completes it. If you're unsure of questions or what they mean, ask your solicitor. To be truthful and accurate with regard to your response, not to provide responses through rose-coloured spectacles or in an effort to encourage a sale. The truth should be told, and the brutal truth told where necessary. If a client doesn't know an answer to the question, they should say so, and a client should notify you, who in turn should notify the buyer's solicitor or conveyancer if there are changes that need to be made to the TA6. Clients need to understand that they could be liable for misrepresentation in the event of stating something in a TA6 reply that is defective. Where there is a deliberate lie with regard to the completion of the form, the seller commits a criminal offence under Section 2 of the Fraud Act 2006. And significantly, a buyer wouldn't need to actually purchase the property or be induced to enter into the contract for the property for a Section 2 offence to be committed. Simply completing the form and lying with regard to information therein would constitute commission of the offence. Right, so acting for a seller, the easy bit. Well, we know this. We should produce replies to standard forms. The conveyancer for the seller should ensure that where additional inquiries are raised that aren't generic, that the seller be asked to complete them. The seller's conveyancer is not required to give any form of warranty with regard to the information in the TA forms, but is under a legal responsibility to check the answers that are provided by the seller against the information that is on file. So we should, when acting for a seller, make sure the client understands what the questions are and what the duties are with regard to providing replies. The client should be told, particularly with regard to the revised TA6, of the need to check information before they respond. There is a case called Rosser against Pacifico, recent case, where the court said if you're answering questions about planning permission or building regs, you should have checked the planning permission and building regulations status of the building before providing an answer. Clients need to understand that you can't give advice on the reply the seller provides, except and save for reminding the client or drawing to the client's attention that what they've said in the TA form is inconsistent with the title deeds or documentation that you hold on file. And again, explain the duty on the seller to disclose changes to any information provided. A failure to do so would constitute misrepresentation. Lessons from case law. Legalistic replies generate potential for greater liability. And not so far as the seller is aware type of response implies that you undertook reasonable investigations before answering the question. Where you failed to undertake reasonable investigations and your response is defective as a result, you'll be liable for misrepresentation. That principle, going back to 1994, has been taken and ridden with in later cases. McMeekin and Long, disagreement and dispute with neighbour, apparently resolved or apparently dormant. Court said sellers under obligation to disclose warts and all, whatever this dispute was, whether historical or current. Judge in this case not deciding whether it was a deliberate lie or wishful thinking on the part of the seller, but holding liability for misrepresentation in any event. Doe and Skegg, no dispute with neighbours, fraudulent misrepresentation. Important point on this case, a wide-ranging question, said the court, warranted a wide-ranging answer. So bear that in mind when you look at the revised TA6 Japanese knotweed question, which asks about the existence of Japanese knotweed on the property being sold, but also about neighbouring properties as well. Put simply, I don't think you can ever advise a seller client to answer the question that there isn't any Japanese knotweed on the property that is being sold. And you certainly can't verify that in connection with adjoining properties. Clinicare, the court said even though there was a survey that revealed dry rot, the fact that the seller hadn't disclosed its knowledge of the existence of dry rot was a misrepresentation. And the takeaway point from this case was the court said you don't have to prove to establish misrepresentation that this fact induced you to enter into the contract and nothing else. There could be other factors that induced you to enter into the contract, but as long as what the seller said or didn't say in the inquiries before contract reply induced you in some way, that is sufficient. Hardy and Griffiths, court said here that one, there was a disclaimer in the inquiries. Two, the buyers had undertaken full investigation relating to the property, and the buyers weren't misled by a mistake made by the sellers in the inquiries before contract, enabled the sellers to escape liability. And Thorpe and Abbott's quite a bizarre case. Buyer sues for misrepresentation because there was a big development scheme in the vicinity of the property. Seller failed to disclose the existence of the scheme. Seller was aware of the potential of the scheme because he'd been invited to a meeting by the developer and planners about what was being proposed. Seller said, yes, on reflection, I did attend the meeting, but at the meeting I was told by the planners that this scheme would not get planning permission. Therefore, there was no need to disclose its existence. Now, I'm not comfortable with that. I think if you talk about wide-ranging questions warranting wide-ranging answers, I think the seller should, in this case, have disclosed the existence of that meeting, albeit with a caveat that at the meeting, the seller was provided with some comfort that planning permission wouldn't be granted. Rosser and Pacifico, 2023 decision, Cardiff County Court. Seller says in replies to the TA6, it wasn't aware of breaches of planning permission or conditions, or it wasn't aware that works were done that didn't carry the appropriate consents. The court held that that was a misrepresentation. The court also held that information received by the buyer from the seller's estate agent showing what was a room on the second floor of the building as a bedroom was also a misrepresentation for which the seller was liable. In Rosser and Pacifico, you had plans and drawings produced showing the room as a second bedroom. You had the room being laid out as a bedroom, and the court said that both of those things would suggest to a reasonable buyer that this property was a two-bedroom flat. The court also found that the estate agent provided drawings and specifications showing or revealing the room as a bedroom, again would induce the buyer to think this was a two-bedroom flat. The answer no given by the seller to question 4.4 in the TA6 carried with it a representation that the seller had reasonable grounds to believe that there was no work that didn't have the necessary consent. Property sold had a skylight in bedroom number 2, which didn't have planning or listed building consent or building consent and approval, and the building control ordered that the roof be reinstated and the window removed, meaning that bedroom number 2 now didn't have natural light or ventilation, meaning that it couldn't be, the building property couldn't be licensed as a two-bedroom flat. Seller sues for misrep. Buyer says, this is a misrepresentation. I've suffered loss as a consequence of buying this flat. It should have been valued as a one-bedroom flat, not a two-bedroom flat. Therefore, I'm entitled to damages. Seller says, no, you instructed solicitors. Those solicitors undertook investigation with regard to the property you're purchasing, caveat emptor. The trial judge said, hang on a minute. No, if you're selling a property, the buyer is entitled to ask questions and is entitled to rely on what the seller says, because the seller is bound to have a greater knowledge of the property than anyone else. The seller should make its own reasonable inquiries before answering questions, and the TA form contained a clear warning to the seller about the importance of answering questions properly. So what can we learn from that? Undertake reasonable investigations before answering questions. Information from an estate agent, incorrectly completed TA forms can lead to liability for misrepresentation. Downey and Henderson, the Japanese knotweed case, same principle. You're answering a question about Japanese knotweed. A, you've got to know what it looks like, and B, you've got to be absolutely comfortable that there isn't the slightest hint or possibility of Japanese knotweed existing on the property that you're selling. If you aren't comfortable with those 2 points, you should say, I don't know what the status of the property is with regard to Japanese knotweed. Other cases, SPS groundworks against Mayhill, an auction case. The person who was a successful bidder didn't complete and was sued for breach of contract. She said that there was a misrepresentation and a failure to disclose a defect in title, which constituted a defence. The court held that yes, there was indeed a defect in title that meant she wasn't getting what she thought she was getting. The point about misrepresentation wasn't pursued in the court, but what she alleged was there was a defect in title, and the nature of the defect was so significant, the auction particulars should have referred to it. And the fact that it didn't, that constituted a misrep. Okay, next thing, sales of leasehold property in the TA7 dilemma, the revised TA7 form. There are questions in the revised TA7 form, question 5, relating to building safety risks. And I would always say when you're acting for a seller completing a TA7, either you tell the client what sort of thing a building safety risk is, and note it's not a building safety risk as defined by the Building Safety Act, but generally, and warn a client about they should really be disclosing to the buyer anything that they're aware of that's been disclosed to them by other leaseholders in the block or building or the landlord. Again, how can you answer 5.9 or 6.2 other than by saying to a seller client, provide me with any documentation or information you've received from anyone about the status of the building or its state and condition. In the revised TA7, you've got new question 11 problems, namely your seller client is being asked about information and they won't be able to provide answers. So what I suggest is you provide an information sheet to the seller client explaining terminology and what sorts of things the seller should be providing in order to properly answer the questions. There are other questions. Has the freeholder landlord been notified of the intention to sell? Well, what is notification? Is it correspondence or an email, or could an oral request suffice? Has the seller received a landlord certificate? If yes, please supply a copy of a landlord certificate. We need to know dates, if we're acting for a buyer, of when the landlord or freeholder has been notified of the seller's intention to sell. We need to know when a landlord certificate was called for and when it was received. And we need to know if the landlord has requested a leaseholder deed of certificate from the seller and whether and when that was produced. So with regard to the TA7, I've got to, I think, do a number of things. One, explain to a seller client that they should be filling the TA7 form in unaided, and explain the potential for liability if a reply is defective. I think we need to provide the client with an information sheet explaining the terminology that's used in the TA forms and what it means, and explain to the client it's not possible for you to check information with regard to accuracy of information in a leaseholder deed of certificate or landlord certificate. And where requests have been made for information or documentation before you've been instructed, you need to tell the client you can't be liable for any issues relating to that correspondence or communication, or if errors have been made relating to service of documentation or provision of documentation. Again, with the TA7 form, I think you've got to preempt additional inquiries, so I'd always ask a seller these additional questions. Has the landlord entered into a developer remediation contract? Does the seller know the status of the flat or the apartment or the building in which the flat or the apartment is situated? Is the seller aware of remediation works undertaken or to be undertaken in connection with relevant defects, fire safety defects, or risk of collapse of the building? When was the landlord notified of the seller's intention to sell? Has the landlord requested a leaseholder deed of certificate, or has one been volunteered by the seller to the landlord? These are important questions that the TA7 form does not deal with properly. Acting for the buyer with regard to these forms, warn the client about relying on replies, explain the potential for misrepresentation and the reality of a misrepresentation claim. So it's all well and good telling a client you can sue the seller for misrepresentation. Does the client know, A, how much it's going to cost to bring proceedings, what the risks are associated with proceedings, and what the likely time frame is before those proceedings are resolved? Client needs to understand all that. You need to report in your report on title on what the seller is saying with regard to answers to TA forms, should highlight where an answer is incomplete or unsatisfactory, and highlight to the buyer client issues associated with risk. The TA6, the revised TA6 that's got everyone excited about at the moment, does a number of things and creates a number of problems. Firstly, given that the idea of the TA6 is that the seller completes the form in isolation without advice or guidance from the solicitor, the fact that the revised TA6 now says talk to your solicitor if you're not sure about a question or an answer puts us in a bit of a dilemma and quandary. So I think we've got to say to the client we're providing explanation and assistance, we're not giving advice. The client also needs to know that the answers to the questions in the TA forms are answers that are the client's answers, and if the clients are wrong or in any way, shape or form defective, there is vulnerability with regard to a claim for misrepresentation. The TA6 includes, the revised TA6 form includes repetition of some of the TA7 BSA questions, includes leasehold questions, as I've just pointed out, includes a wide-ranging Japanese knotweed question that I think a seller properly advised cannot complete. It also requires material information to be provided for estate agents, which may well be provided before you're instructed, and part 2 questions, which are required to be completed during the conveyancing process. To what extent are you required to check what the seller says in the part 1 information and to correct what the seller has said if any of the information in part 1 is defective? I think you are under such a duty. And as far as part 2 is concerned, I think you're now under obligation to highlight where in part 2 there are questions that suggest to the client that guidance or assistance is sought. So acting for a seller, make sure clients know what to check before providing replies, warn clients about getting questions wrong or answers to questions wrong, explain the limitations relating to your assistance and advice, and when you get the forms back from the client, cross-check it against information on your file, and again warn the client where there appears to be anything that is defective or incorrect. And when acting for the buyer, explain and advise about information received from the estate agent could generate liability for the seller by way of misrepresentation. Explain the potential for claims, but explain the problems with regard to practicalities of bringing the claim. Explain the concept of let the buyer beware. In other words, the buyer is deemed to have knowledge of the property in its state and condition and has limited rights of redress if after purchase the property is not as described. And make sure the client inspects the property carefully and that the client is told to get the best survey or valuation they can afford. I repeat, the RICS has a consumer guide to survey and valuation, which is invaluable. I was talking to a firm last week who provides every client with a copy of the RICS consumer guide to survey and valuation. The firm recommends a level 3 survey, but that consumer guide highlights the disadvantages of other types of survey or valuation. Can a buyer raise additional inquiries where their contract bundle is received? Answer, yes. Can't raise generic inquiries, but can raise inquiries where the buyer client asks for inquiries to be raised or where information provided by the seller is incomplete or inadequate. As far as the TA10 form is concerned, again, clients should understand about fixtures and fittings. Clients should be warned about the apportion point that I mentioned when we talked about drafting the contract. There might be items that are being left by the seller, electrical items in particular, and we might want warranties as to state and condition. We might also want warranties for the seller that items that are being left are not subject to any form of finance. Other documentation that we might encounter and utilize in connection with the preparation of the contract bundle, guarantees and reports relating to guarantees. documents referred to in the official copies of the register I've mentioned, evidence of change of name, and other documentation that can generally be produced. In leasehold transactions in particular, there could be a whole raft of additional documentation that we would require. Unregistered land for the contract bundle, land charges search against the seller and other appropriate names for their period of ownership, a SIM search, an epitome of title, and documents on which the buyer should be reasonably expected to rely upon. Make sure that plans are properly coloured, and if in doubt from a seller or buyer's perspective, have a think about voluntary registration. With leases, in addition to all that documentation, we're going to want to see the lease. If the lease has been varied, we want to see deeds of variation, and we need to make sure those deeds of variation have been registered. In a leasehold property, we want to see an LPE1 from a landlord, and we need to check if it contains any form of disclaimer. We need the seller to produce TA6, TA7, and TA10. In a leasehold transaction, we need to see up-to-date management regulations, if there are any, service charge accounts for the last 3 years, and a ground rent receipt for the current year. If you're acting for a buyer with regard to service charge accounts, you should warn the client that they may not, in fact, be representative of current service charge. Just because for the last 3 years the service charge has been in or around the £1,000 mark wouldn't necessarily mean the service charge for future years is going to be at that sort of level, far from it. As far as management regulations are concerned, make sure you see the up-to-date regulations. Where a building is a relevant building or a higher risk building, there could be a whole raft of additional documentation that the seller will produce. Particularly with higher risk buildings, we're likely to see building safety management documentation produced by the landlord and transmitted to the seller that the seller is likely to want to transmit to the buyer. That, ladies and gentlemen, is a scamper through some of the basic issues with regard to the contract bundle. Now, Robert, I don't know if you're listening, but I did mention a couple of points at the start of my presentation concerning title indemnity insurance, and 2 questions for you, Robert. First of all, would you agree with me that the buyer should be taking out the policy rather than the seller, but the seller should be indicating at the start of the transaction where there is an issue to which defective title can achieve some form of resolution?
Yes, Ian, I would agree entirely on that, particularly as the Insurance Distribution Directive, which is now incorporated in the FCA handbook, does place obligations regarding demands and needs statements. And if, as the seller's lawyer, you're purchasing a policy for the benefit of the buyer, you could be setting up a contractual relationship between yourself and the buyer. It's much better just to agree on apportionment and leave the actual buyer's lawyer to get the policy which is appropriate for their client and their lender.
Thank you. And the other point I made is the fact that you as an organisation have the solution sort of online facility, but also you can create bespoke policies depending on what people need. Again, any comment on that?
Yeah, I mean, the online system, Stewart Solution, does provide cover for 150 of the standard transactional risks, which tend to be the ones you'll be looking at here. But obviously, there are always cases where the information needs to be varied, so you can start a quote online and then be transferred through to the underwriters. So it does allow you to do it there. We also now have variable assumptions on our online policies, which enable you to sort of, I shouldn't use the word bespoke, but it does allow you to bespoke the policy slightly to fit your client's situation. So both routes are available for you.
Okay, thank you. So unless you've got anything else to say, Robert, all I'd like to say is thank you very much for inviting me along. Secondly, there is a feedback form that Stewart Title would like you to take a few minutes out to complete. This is really useful for both Stewart Title and myself to see, what you require, what we can do to help. And do hope you can come along to the next one. We have recorded this session. There are notes that accompany this session. And as I say, if there are questions or issues arising, contact Stewart Title or myself, and we'll endeavour either to get back to you in a timely way before the next session or to deal with it at the next session. But Robert, I think on that note, we're done, aren't we?
Okay, well, on that, I think we've finished that. Any more questions, please send them through. We'll talk about them next time. Please complete the survey on your way out, and we look forward to seeing you all next week at the same time. Thank you very much.
Thanks, Robert. Thanks, everyone. Stay safe. Bye-bye. Bye-bye.